Can we refresh and then I will get it?
Yes, ma'am.
Just
Once
5
it is
minutes.
short notes, ma'am, it is coming in 1 minute, it is for print off.
Okay, we'll pass it over there.
Yes.
For admission, item 14, WPL 800 of 2022.
Get us the soft copy also. Petitioner.
Like there is no short passover in this case. Mr. Master will not do his online import number here.
Passover. Ask him to be to come tomorrow. Let it be tomorrow because he's already on legs.
Yes.
Post tomorrow. Council seeks adjournment.
Item 15, WPL 1047 of 2022.
We should take for 2 weeks time. We have received the counter yesterday.
Counter affidavit is dated, we have served a copy, we will file.
WPL number 1047 of 2022. Council for the parties are present. Council for the petitioner. Praise is granted time till. How much time do you need to rejoin?
2 weeks.
Time till 3rd of April 24 to file a rejoinder to the counter affidavit. Was this case on 7th of May 2024. Synopsis, list of dates and the judgments which the parties are seeking to rely upon must be filed by 30th of April.
DPL.
Item 16, WPL 3233 of 2022.
Petitioner.
Yes, notices have been issued, madam, on 4th of September 23. Thereafter, nobody has appeared.
Notice has been served.
But nobody has appeared.
Let them not appear. How are you concerned with that?
In that case, can you be tomorrow, madam?
Your point is very short.
Very short one, there was no relationship of employer and employee, madam. There is nothing on record to show that we had issued him the work order to rectify the voiding order.
Who filed the application?
The wife of the concerned worker.
You come to page 53. 8/3/16
किसी की ओर से हाजिरी दी गई, आवेदक अनुपस्थित है, बात पुकारा गया, बात पुकार में आवेदक की ओर से कोई भी उपस्थित नहीं रहा। अभिलेख अवलोकन से यह प्रतीत होता है कि आवेदक दिनांक 10/11/15 से लगातार उपस्थित रहे हैं, न ही आवेदक के विद्वान अधिवक्ता की कोई पैरवी की है। इससे यह प्रतीत होता है आवेदक को अब इस बात में कोई भी अभिरुचि नहीं है, वो तो खारिज कर दिया। दैट इज आल्सो वन ऑफ द पॉइंट्स
इसके बाद क्या हुआ?
खारिज कर दिया गया। Thereafter, there is nothing on record to show that it was restored.
Did you participate thereafter?
Yes, sir. We participated. 13/12/2017, your lordship will see, but we went for a public notice published in the newspaper.
What is the direction issued to you?
Payment, we were directed to make payment of. Yes. 7,31,362 as compensation.
Compensation for what?
Workman Compensation Act, under the Workman Compensation Act. He was not a workman, so Workman Compensation Act will not apply.
He was not a workman. There is no evidence that he was
No
a workman.
evidence, madam.
Let us see, there must be some, you must have raised this issue that
Yes,
he
we
was
have
not a
raised this.
workman.
Then let it be tomorrow first case.
Okay. WPL number 3233 of 2022. In spite of service of notice, nobody has entered appearance on behalf of opposite party. The learned counsel for the petitioner submits that finding has been given on,
Yes.
has submitted that finding has been recorded by the learned court that there was a relationship of employer and
No,
employee.
there is no finding to that effect.
Okay.
That is basically my point.
Yes, the learned counsel has submitted that. The learned court has not recorded any finding regarding the point of relationship of worker and management between the parties. Although the dispute was raised by the petitioner before the learned court. In absence of such finding, the findings recorded by the learned court, the directions issued by the learned court for payment of compensation under Workman Compensation Act is not sustainable in the eyes of law. However, in order to place the award, the petitioner submits that the matter be taken up tomorrow. We'll see tomorrow. If required, we'll call for the records. You have to show the dispute and the findings. Both.
For judgment item 1, WPS 2543 of 2023.
This writ petition is dismissed. You will get the uploaded copy.
I can see the records.
Records?
I'm the order from the court.
No, you see it once it is uploaded. Because I have pronounced it, but I have not finally scrutinized it. Just once we need to take a glance, some grammatical error and things like that. I have held that your document was not the required document as per the provisions of that dispute.
Item 17, WPS 284 of 2023.
In pursuance to the earlier order, Lord, the state has filed counter affidavit in this case, Lord. I have to file rejoinder.
WPS number 284 of 23.
And Lord, I will file list of dates also.
वो जो अभी एक ऑर्डर की ना रिजॉइंडर का, सेम ऑर्डर कर दीजिए 7 में and rejoin and synopsis list of dates by 30th April.
I need to submit my list of dates and submit.
You also do it. That helps in dictation of judgment.
Item 18, WPS 322 of 2023.
Counter file हो गया सिर्फ rejoinder के लिए.
This case was praying for password of few cases. The senior has to argue as password for few cases.
Counter file.
Yes.
Do you want to file a rejoinder?
Rejoinder also.
What is the matter?
What is my return, but there is a punishment order which is under challenge before this one.
What is the nature of punishment?
Not on the direction of Lokayukt, the proceeding has been initiated, and after conclusion of the proceeding, punishment has been imposed.
The learned counsel for the parties are present. Considering the points involved in the present case, let this matter be admitted for final hearing.
Senior basis, just password for few cases.
I am just admitting it, I am not dismissing it. It requires full-fledged hearing. Rule is made returnable on 5th of December.
Item 19, WPS 393 of 2023, along with item 20.
You on 5th, time passes very fast. If you file your synopsis, list of dates, etc., and if this court continues, I will surely try and hear it. 5th December. You have sufficient time, prepare yourself. Yes, please.
Not the petitioner, not the granted promotion, not to the post of headmaster, grade 7, not the lecture 2 in the order, not the promotion order.
What is the cause of action?
Not cause of action is not the promotion is granted, but without monetary benefit.
What is the illegality in this order?
Not promotion always carries with the monetary benefit.
And there is no concept of notional promotion without monetary benefit?
Notional promotion can be granted if there is a lacuna on the part of the
You have filed your
petitioner.
counter.
Yes, Lordship, we have filed the counter with Lordship. Even we have annexed 2 judgment, Lordship, at para number 16 and 17, Lordship. In the judgment, we have stated that the promotional benefit can only be granted from the date of issuance of the promotional letter, Lordship. And the second is regarding, Lordship, the promotion cannot be granted,
Both judgment are not.
can be granted, promotion can be granted retrospectively and extended to give benefit and seniority from the date of national vacancy, Lordship. Lordship, if they get the national appointment to leadership, then they cannot claim the monetary benefit to leadership. This is the well settled leadership.
Do you have this?
No, not in this case itself, annexure 1 is the grade 4 promotion. Grade 4 promotion is not the.
There is one circular of the state government in this regard.
Lordship,
Where is
we
that
have also
circular?
annexed.
You have annexed circular?
No, Lordship, not the particular annex.
There is a particular annexure in connection with school teachers, grade 1, grade 7, grade these grades,
Lordship,
where
please-
it says that that upon getting promotion, they will be entitled to monetary benefit on the date the promotional order is issued. Where is that circular?
Right now, I don't have that circular.
Your
Lordship, but-
authorities are not aware of that circular.
Lordship, please come to annexure D, Lordship, at page number 36.
Yes. This is in connection with whom?
ट्रेन टीचर्स के बारे में जो ये रूल सर्कुलर हुआ है उनके जजमेंट के कंप्लेंट्स में कि अनट्रेन टीचर्स विल get the grade 1 from the date of appointment and seniority from that date. This is also not applicable. So
Where
that-
is the rules by which you are governed?
Milord, the rule, Milord, there is no rule. The rule, Milord, Rule 56 and Rule 74, Rule 56 of Bihar Service Code and Rule 74 of the Financial Rule, Milord, that speaks about the, upon the
I want to know where is the rule which governs your promotion?
1993 rule.
Where is the rule?
Rule, 2 week time may be granted, I will bring on record. Milord, because my promotion is not in dispute. Promotion is granted. Only,
Vacancy was there.
yes,
Gradation list was there.
yes, promotion granted, Milord.
Granted, that's right. You are seeking promotional benefit from a particular date.
On
From
the
the
date when
monetary
promotion
benefit.
is granted. हुजूर केवल दो election
नहीं 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 आपका रूल ही नहीं है. Where is the rule? I cannot. You can argue without the rule. I can't decide without the rule. Can I decide without looking at the
तो
rule?
रूल को हम लगा देते हैं. रूल को फाइन कर देते हैं. 2 week time में भी granted. एक के दोनों केस एक ही है जो एक केस में रूल को ले आ देते हैं.
Which two matters?
19 and 20 both have the same.
The learned counsel for the petitioner seeks adjournment to bring on record the applicable rules governing the petitioner with regard to his promotion by filing a supplementary affidavit. Let the supplementary affidavit be filed by 1st of April. Post on 3rd April. This is for fresh filing.
No addition.
इसको जो है ना फाइनल डिस्पोजल में लगा दीजिए. You file all the judgments you want to cite, right? And file your synopsis and list of dates also.
I will also.
And there are numerous judgments on this,
Yes, ma'am.
right? You file those judgments.
I
And
think
cases of various other persons which have been decided. Okay? वो list of dates वाला कर दीजिएगा. Must by 1st of April.
Item 21 WPS 500 of 2023.
Filing the reminder to the counter.
WPS number 500 of 2023. Counsel for the petitioner prays for and is granted. अभी एक order किए ना same order कर दीजिए. Right? It will come on 7th May.
7th April.
7th May. And you have to file your rejoinder by what's the date? 30th April.
Item 22 WPS 711 of 2023.
Well, I want to file the counter exhibit has already been filed.
Same.
Item 23 WPL 914 of 2023.
On 14/9 to 30.
Where is the respondent?
Notice was issued and it was filed, both process filed.
Okay. What is your case?
Madam, it is against the award. Sole ground
What
I have
is your-
taken, madam,
Yes, whole ground.
that the medical representative will not come under the purview of ID Act. And it has been held by the division bench of the Patna High Court that since they are not doing the such job that will come under the purview of ID Act, and that's the provision of ID Act is not for the medical representative. My lord, may kindly have a look. to page.
It's under Shops and Establishment Act or
No, it was under ID Act.
Let us see the impugned order.
My lord, first of all, my lord, I would like to place page 107. Which is the operative part of the judgment of the Patna High Court.
First place the impugned order.
Impugned order is at page, my lord, it starts from page 27. The sole respondent had been discharged from the job, and thereafter, my lord, the matter went to the before the conciliator, which was paid, and this case has been filed before the London Labour Court by the union, BSS union, which is not recognized by the petitioner here.
You just said that the sole point is whether they are covered by.
Yes.
So stick to that point first.
That's why, my lord, I have placed 107, page 107.
Page 107, what is the finding of the Learned Labour Court on this?
Tribunal has held that he is the workman under the ID Act.
So where is that finding?
Yes. Now, my lord, may kindly have a look to page.
Where are the issues
Page
framed?
83, my lord.
Where are the issues framed?
My lord, page 34.
30. Let us see what all are the issues.
Altogether, 8 issues have been framed.
Read it, please.
On the basis of pleadings of the parties, following issues have been framed for the adjudication of the matter. Whether instant case is maintainable in its present form, whether petitioner is entitled or authorized to file instant case on behalf of the employee Mr. Santan Kumar, whether employee Mr. Santan Kumar is workman within the meaning of section 2S of Industrial Dispute Act, whether this court has got jurisdiction to try and proceed with the instant case, whether termination order of workman Mr. Santan Kumar is bad in law, and whether termination order has been passed keeping in mind settled principle of natural justice, whether concerned workman is entitled for reinstatement in service with full back wages, whether domestic inquiry conducted against workman was in accordance with settled law and in compliance with principle of natural justice, whether workman is entitled for any other.
Issue number 3 is the most important issue.
Yes.
Okay, let us see issue number 3 starts from page number 41.
Para 15.
Para 15.
It is an admitted case of both parties that Mr. Santan Kumar was appointed on 8/4/2005 as training medical sales representative, while Exhibit 1, and his headquarters was Aligarh, UP. Later on, his services was confirmed and he was transferred to Ranchi, and he joined on 18/8/2008, while Exhibit 2, as MSR. MSR stands for Medical Sales Representative. In Inspira division, further his service was discharged while later dated 23/3/2013, Exhibit 11. It is also admitted fact between both parties that at the time of discharge from the service, Mr. Santan Kumar was posted as medical sales representative, and his work was neither administrative nor managerial and not supervisory. In the light of above factual aspect of the matter, question calls for consideration whether a medical sales representative is workman within the meaning of section 2S of the ID Act, or whether discharge of Mr. Santan Kumar is covered under the Industrial Dispute Act.
This is rightly recorded. This recording that it was an admitted fact that Mr. Sanatan Kumar was posted as medical sales representative and his work was neither administrative nor managerial nor supervisory.
My lord, this was our argument that his case was not covered under the section 2S because he is drawing salary of more than 10,000, which is the keyword in the section 2S.
Let us see.
In case of HR Adantya versus
No, that's right. These are all judgments. Where is the finding ultimate?
It is at
They are
page,
just referring to the judgments.
page 83, madam.
Page 83.
My lord, para 20. 63 mean.
Page number 83 does not have para 20.
63, paragraph 63.
Para 63.
Yes.
This is quantum of packages.
Back
No, I just want to know the finding with regard to issue number 3.
My lord, 62 में 62 उसी के ऊपर
62 नहीं.
पेज 83 में
Issue number 3
हाँ,
जहाँ
उसी
खत्म
में.
हो रहा है वहाँ बताइए. Page number 83 में
in view of finding of issue number 2, 3, 4, 5 and 7.
where is finding with regard to issue number 3?
वही जो अभी हम लोग पढ़ रहे हैं.
No, that is just a beginning.
Oh, उसका
Page number
41.
60,
Page
para
40.
number 36. No, it is here. This is issue number 4.
उसी में किए हैं उस जजमेंट को कोट करते हुए पारा 16 में पेज 42 में लास्ट में 43 में आए देखेंगे.
You just come to page number 55.
पेज नंबर
55. Para number 24.
para 24. Therefore, in the light of above decision, it can be concluded that sales promotion employees will not fall under the definition of section under section 2S of ID Act, but on and from 6/3/1976, the provisions of Industrial Dispute Act are applicable to sales promotion employees depending upon their wages on up to 6/5/87 and without the limitation of their wages thereafter, and upon the capacity in which they are employed or engaged.
Now you come to page number 54.
54.
From 6th of March 1976, the provision of ID Act became applicable to medical representatives depending upon their wages up to 6th of May 1987 and without the limitation on their wages thereafter and upon the capacity in which they were employed or engaged.
This was the judgment, my lord, which has been quoted in the case of Sandoz. In Maharashtra, my lord, this provision has been enacted. In our state, my lord, this provision has never been enacted.
This is an amendment in Maharashtra.
In Maharashtra,
From where do I
so
get
far
this?
my knowledge is concerned,
Please say something from the records.
it was held in the case of Maharashtra, my lord.
You must have said so something
हाँ,
about
HR
it.
Adantya, my lord, may kindly able to pay prior to one page, my lord, 53, para 23, HR Adantya versus Sandoz India Limited. इसी में ये आया था, ये हम पर जजमेंट पूरा कोट किए थे.
So,
And held that medical representative will not fall under the definition of workman, as under. With due respect, the Karnataka High Court has not passed a reasoned judgment. Rather taking into consideration the part of the observation made in paragraph 4, ये हम लोग के झारखंड हाई कोर्ट में एक केस हुआ था, इंडियन ड्रग्स एंड फार्मास्यूटिकल, उसको कोर्ट किए हैं. Taking into consideration the part of observation made in paragraph 4 of the judgment of the Supreme Court in H.R. Adantya case, such and such, decided the issue. The relevant portion of the observation quoted in the posted judgment by Karnataka High Court has lost sight of the fact that consequences of subsection 2 of section 6 having been omitted by Supreme Court further observed as under. Section 6 of the Act made the Workmen's Compensation Act 1923 Industrial Dispute Act 1947, IDF, Minimum Wages Act 1948, Maternity Benefit Act 1961, Payment of Bonus Act 1965, and Payment of Gratuity Act 1972 applicable forthwith to the medical representatives. Subsection 2 of the said section, while making the provision of Industrial Dispute Act as in force for the time being applicable to the medical representative, stated as follows. The provisions of the Industrial Dispute Act 1947 as in force for the time being shall apply to or in relation to sales promotion employees as they apply to or in relation to workmen within the meaning of that act, and for the purposes of any proceeding under that act in relation to an industrial dispute, a sales promotion employee shall be deemed to include a sales promotion employee who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment had led to that dispute.
What does it mean?
My lord, the
Which
sole respondent,
judgment clearly says that medical representative per se are out of the picture? Because it is referring, this judgment, impugned judgment, is referring to certain notification of 6th of May 1976. What is your response to this?
my lord, the petition which has been preferred by the sole respondent before the learned labor court is under the IDF. My lord. It has never been filed with under the provision of Sales Representative Act.
Sales Representative Act there is no such act.
My lord,
There is no such act called Sales Representative Act.
it has been filed under the Industrial Dispute Act.
That's right. Under 1976 Act, certain provision was made to include them.
So, my lord, in 1976 Act, my lord, it says, my lord, that the person who is drawing salary more than 10,000,
Where is that 10,000? From where do you get 10,000?
it is under the Act, my lord.
Show us.
IDF.
You don't bring your own book.
My lord,
Not
I was reading in my table, my lord. I left the book in my table. My lord, I am reading section 2S4. Who, being employed, page 20. Page 20.
2S4.
Yes, ma'am.
Yes.
Who, being employed in supervisory capacity, draws wages exceeding 10,000 rupees per mention or exercises either by the nature of the duties attached to the office or by the reason of the powers vested in him, function mainly of the managerial nature. So, my lord, the section itself is clear that when the
So any workman, according to you, who draws more than 10,000 salary is excluded. तब तो सारा का सारा जितना भी ID Act में cases चल रहा है सब void ab initio हो जाएगा.
तो
पूरे
जो
झारखंड
एक्ट बोल रहा है हम तो उसी को प्लेस कर रहे हैं, एक्ट ही यही बोल रहा है।
उसके साथ में मैनेजरियल कैपेसिटी भी लिखा हो.
हाँ, तो मैनेजरियल कैपेसिटी इनका पोस्ट ही वही है। मेडिकल सेल्स रिप्रेजेंटेटिव is the man who represented the company for sale of the medicines which has been given to you for promotion, and every decision has to be taken by himself. So our case is that he was under the managerial position, and so he will not come under the purview of section 2A as defined in the idea. And this has been dealt by the Honorable Patna High Court referring the judgment of Sandoz case that I have annexed in my petition also, my lord. My lord may kindly have a look to page 107, my lord. 107 of my brief, my lord.
Yes, Anand. Yes.
Thus, in the light of the law laid down by the apex court, both in the case of HR Adantya Supra and Ron Polnek Limited, it has to be held that a medical representative, in view of not performing duties of a skilled or technical nature, cannot be held as workman under IDA. Once this judgment has been passed in NPM by the division. Once I come to the conclusion that the appellant was not a workman under the IDA, obviously the reference itself before the labor court under section 10 of the IDA Act has to be held wholly without jurisdiction, rendering the impugned award a nullity in the eye of law. I must hasten to add here that even if for sake of argument, I accept the submission of the learned counsel for the appellant that the appellant was a workman and was covered by the provisions of IDA, even then, the findings arrived by the learned single judge in respect of such and such being neither modified nor in contempt. So, my lord, it has been held by the division bench of the Patna High Court that the medical sales representative will not come under the IDA. And this provision, my lord, has been constantly held by the Madhya Pradesh High Court. Also, I have also annexed the judgment passed by the Madhya Pradesh High Court.
Please, sir.
नहीं उसको नहीं लगाया हुजूर, अपने हाई कोर्ट का लगाए हैं, इंडियन ड्रग्स एंड फार्मास्यूटिकल लिमिटेड, उसको हम रेफर किए थे हुजूर, वहां पर वो लगाए नहीं. My lord, the page 110.
I've seen it. Basically, your argument is on the basis of the judgment passed in the case of HR
Adantya versus the Sandoz India Private Limited, and the dismissal of the workman is also, my lord, on the point of non-functional and disobedient to the which any work which has been given to the sole respondent that will not done by the respondent, that has been discussed also, my lord, in the impugned judgment. Our one more point is there that the union has never been recognized by the company, BSSR union. So there was no locus standi to file any petition before the labor court on behalf of the employee, Santan Kumar. My lord, it has come in the evidence that the Santan Kumar was drawing a salary of rupees 11,253. Page 30 may kindly be seen. In excess to rupees 10,000.
You have to show everything from the impugned order.
Yes, I am placing.
You are placing some annexure.
My lord.
It is an exhibit.
It was in the evidence. It has come in the evidence. So for that, my lord.
This is exhibit number.
My lord, it was exhibit. It was evidence, my lord. It has come from the mouth of the witness, my lord. So LCR in that regard, my lord, LCR is required. In that regard, my lord, LCR is required because I have to place certain things from the LCR which has come from the mouth of the witnesses.
That's all. Anything else you want to submit?
One more thing is there that the jurisdiction, my lord, in appointment letter, it has clearly mentioned that all the disputes shall be subject matter at Mumbai. So on that point also, my lord,
Was any issue raised on this point?
it has not never been issue. Only issue was that the labor court has any jurisdiction to. This was the issue before the labor court. Whether this court, issue number 4, page 34, whether this court has got jurisdiction to try and proceed with the instant case.
So issue number 2 is under cloud, issue number 4 is under cloud, and which issues are under cloud? Tell us.
3 also, my lord.
3 I have marked, 4 I have marked. What else?
And the labor court has given 50% of back wages, my lord, without performing any duties in intervening.
So Roman 6.
Yes.
So these 3 issues are under cloud, right? And Roman 2 also. You said that the labor union
Yes,
was not.
yes, yes.
In spite of service of notice, the respondent has not appeared. The learned counsel for the petitioner, while assailing the impugned award, has referred to page number 34, para number 9 at page number 34 of the petition, and has submitted that as many as 8 issues were framed, out of which the petitioner is aggrieved by the decision on issue number 9 within bracket Roman 2, within bracket Roman 3, Roman 4 and Roman 6. The learned counsel submits that the core issue involved in the present case is whether the petitioner, who was working as medical sales representative, would be covered under the definition of workman as defined under section 2 within bracket S of Industrial Disputes Act. And for this he has placed the definition of workman as defined under Industrial Disputes Act and has referred to clause 4 thereof to submit that a person who is employed and is having a salary of more than 10,000 rupees is not covered as workman. The learned counsel has also relied upon the judgment passed by Honorable Patna High Court in LPA number 1430 of 2009, decided on 19/1/2011, and has, as contained in Annexure 4 to the writ petition, and also a judgment passed by this court reported in 2004 within bracket 3 bracket close JCR 231 within bracket JHR as contained in Annexure 5. The learned counsel submits that the impugned judgment is especially perverse. The respondent union had no authority to represent the workman, as the said authority, as the said union was not a recognized union by the petitioner. That's all.
The workman was not discharging his duty as per the norms of the company.
The learned counsel has also submitted that the workman was not discharging his duty
And he was
as per the instructions, and therefore
indulged
without
in
prejudice to
irregular
the.
reporting.
आपको सुन लिए तो फिर बीच में क्या बोलना है?
अभी ये कुछ
आधा घंटा से सुन रहे हैं ना आपको? Have I completed my dictation?
मालूम पूछिए अभी तक बताइए
क्या पूछे हम?
कि और कुछ तो उसने बताइए मालूम has asked.
The learned counsel has also submitted that the workman has not performed his duties as per the instructions issued to him from that time to time, and therefore also, and without prejudice to the aforesaid submissions, the grant of full back wages,
50% of them.
50% back wages is not justified. That's all.
50% and order of discharge has been set aside. That is also.
And the order of discharge has been wrongly set aside.
One more thing. The jurisdiction for any dispute arising out of at Mumbai, as the
Learned counsel has further submitted that
appointment letter has been signed by.
as per the appointment letter,
That is exhibit, my lord.
the
Exhibit 1.
jurisdiction in connection with the dispute could have been raised only in Maharashtra,
Mumbai.
only in Mumbai, and therefore the dispute raised in Jharkhand could not be entertained by the Learned Labour Court Ranchi. That's it. However, during the course of argument, it transpired that the petitioner was that Mr. Sanat Kumar, the concerned medical sales representative, was transferred to Ranchi.
His appointment was at Ranchi. Aligarh, that was thereafter.
Was
Aligarh.
transferred to Ranchi
Yes, ma'am.
at the relevant point of time, and it further transpires from paragraph 15 of the impugned order, wherein it has been specifically recorded that it was an admitted fact between both the parties that at the time of discharge from service, Mr. Sanat Kumar was posted as medical sales representative, and his work was neither administrative nor managerial nor supervisory. Arguments concluded. Moves for judgment. Acting judgment will be taken.
All right. My lord, I will be allowed to place judgment of my lord Madhya Pradesh High Court. My lord.
Your arguments are concluded. Now the matter is posted for judgment. Right. Now you cannot place anything more.
Okay.
(23rd April). पास हो गया अभी पास ओवर का टाइम
फिक्स ना कीजिए
वो आगे रुक जाइए बस कॉल कर
Item 24, the LPS 977 of 2023.
I'm paying for not players. Army council is some medical reasons he is not available.
Who is the admin counsel?
Mr. Kumar has to argue this matter.
Mr.
Kumar Harsh. Who is the person?
You have filed your counter.
It will be filed later within a day.
It has been filed.
Supplementary counter affidavit was supposed to be filed. The medical examination report was supposed to be brought on record according to the last occasion.
Why have you not brought it on record?
Later, the instructions have received. Will file in a day or two.
You have received the instruction. Show me the medical.
Later,
You have kept it at home. WPS number 977 of 2023. Counsel for the parties are present. Counsel for the respondents has submitted that the required instruction, including the medical report, has been received and prays for 2 days' time to file a supplementary counter affidavit to bring it on. Pose this case on Monday under the heading for final disposal. The supplementary counter affidavit be filed by day after tomorrow. Further time मांगेंगे ना तो 8 लाख रुपए कॉस्ट लगाएंगे, not less than 1 lakh rupees. And this is recorded and I will remember it. You have said that you have received the instructions. 2 दिन समय मांगे हैं, 2 दिन हम आपको टाइम दे दिए.
Item 25 WPS 1148 of 2023.
Once the rejoinder is ready, the petitioner, due to some ailment, will attach the rejoinder.
Sorry?
The petitioner, due to some ailments, is unable to attach the rejoinder, claim for monthly.
How much time do you need to file the rejoinder?
The petitioner is,
So I'm just asking you, how much time do you need to file the rejoinder? I'll give you time of your choice. You tell us. 1 week is sufficient. Have you taken instructions? Then I can give you 10 years time. You want? You just give me the exact time, because that will be by way of last indulgence. We will not give you further time. Your senior has not given you the time you need. कितना दिन बताइए?
medical emergency now, I have not been available.
Who is in medical
The
emergency?
petitioner. 2 weeks.
Then we can adjourn it. Sanitary, you mentioned, file your rejoinder and mention as per your sweet will.
Well, the rejoinder is ready, sir. Just want me attached.
WPS number 1148 of 2023. Counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 15th of July to file a rejoinder in the said case by way of last indulgence. काफी है ना? चलिए. Post on 22nd.
Item 26 WPS 1624 of 2023.
Yes.
But the petitioner, in the employ of CRPF, has short prayer, has prayed for this amount for grant of MSc after completion of 10 years continuous service. But his representation on that issue has already been rejected during pendency of this petition matter. So that's why I have filed one interlocutory application into 3 years of this for amendment in the prayer. That is paragraph 10 of my earlier petition.
This is the order has been passed prior to filing of the
Prior to filing, but that was not communicated. I have categorically stated to why that was not communicated. That was not communicated. It came to the petitioner's knowledge only after filing this writ petition. that is the order of.
So now you will have to assail the grounds on which they have rejected.
Madam, that is, if
Then you
Lordship
file
will
a
allow
fresh writ
me.
petition. Because now they have given specific grounds for rejection.
That
File a
is
fresh
due to
one.
qualification, that is
So you
metric
file
and
a
non-metric.
fresh one because that aspect has to be properly addressed by you in your pleadings so as to enable them to respond to it.
But if Lordship will allow me to just file a fresh or amended writ petition.
I will permit you to file a fresh one. You file a fresh writ petition because now the impugned order has to be assailed on specific grounds, referring to the grounds which has been mentioned in the order.
In the several judgments were passed by this coordinate bench of this
therefore,
court.
So therefore, you need to challenge it specifically to that effect. You file a fresh writ petition.
Or your Lordship may allow me to file amended writ petition. So that in the same amended writ petition, if some grounds may be permitted to.
You can have a better grounds. You see, the foundational basis for your seeking the relief is not there in the writ petition. Because it was filed under an assumption that now the decision is yet to be taken. Once the decision is taken, the question WPS number 1264 of 2023 with IA number 238 of 2024, the learned counsel for the petitioner has submitted that interlocutory application has been filed to challenge the decision dated 9/1/2023, whereby the claim as made by the petitioner in this particular writ petition has been rejected by passing an order. He submits that at the time of filing of the writ petition on 21/3/2023, the order sought to be challenged through interlocutory application was not in his possession, and therefore the same could not be challenged at the time of filing of the writ petition. The learned counsel for the respondents has submitted that now the petitioner will have to take specific grounds to challenge the order dated 9/1/2023, and therefore the petitioner may file a fresh writ petition instead of amending the present writ petition. He has also submitted that the foundational grounds to challenge the order dated 9/1/2023 is not available in the main writ petition. After hearing the learned counsel for the parties and considering the fact that the claim of the petitioner as prayed for in this writ petition has been rejected by a recent order dated 19/1/2023, though passed prior to filing of the writ petition but was not challenged in the writ petition, as it is contended by the petitioner that the same was served upon the petitioner subsequently. This court is not inclined to proceed any further in this writ petition and allow the petition seeking amendment, as the order dated 19/1/2023 has to be, if so advised, has to be challenged by taking specific grounds, challenging the reasons mentioned therein. In such circumstances, the writ petition is disposed of, keeping the right of the petitioner to challenge the order dated 19/1/2023 annexed with the interlocutory application intact. Right? This writ petition, IA closed, writ petition is disposed of.
Item 27, WPS 0215 of 2023.
On instructions of the advocate on record, I pray for 3 weeks time to file a rejoinder to the counter affidavit filed by the state members.
WPS number 2215 of 2023. Time till 3rd of April is granted to the petitioner to file a rejoinder to the counter affidavit. post on 7th of May.
Item 28, WPS 2369 of 2023.
Counter affidavit, they have filed on 28/2/23.
Same order. Rejoinder you have to file, no?
Only this law, only this law.
Item 29, WPS 2656 of 2023 along with item 30.
Lordship, I am praying that the matter will be fixed for tomorrow, Lordship.
Sorry?
Matter may be fixed for tomorrow, Lordship.
Tomorrow, who will argue the case?
Mr. Sokumar Yadav, Lordship. Due to personal difficulty, is not in the court, Lordship.
What is the cause of action to file this case? What is the cause of action to file
Cause
this
of
case?
action is, the petitioner has filed this petition directing the respondent to publish the result of the examination for appointment of home guard on the basis of the advertisement number 1 of 2009. Now, in my humble submission.
When was the examination held?
Madam?
When was the examination held? When was the examination held?
Examination का
2009 का एडवर्टाइजमेंट था 11 में एनेक्सर 4 पेज नंबर एनेक्सर 4 लॉटरी में कहेंगे पेज नंबर 58-59
When was the examination held?
2000 कब हुआ था?
When was the examination held?
11 madam 2011
2011.
page 58-59
Page is not required. Sir, you tell me that when was the examination held? You have filed a petition concerning 2009 advertisement.
yes
More than 13-14 years have passed. So I want to know that when was the examination held?
examination was in 2011
So what were you doing these days?
Actually, madam, in my humble submission, in the entire state of Jharkhand, madam, the appointment was to be made of the home guard on the basis of the advertisement of 1/2009. On the basis of that advertisement, in the entire district of the state of Jharkhand, the appointment of home guard has been made. Now, only in the district of Godda, though the petitioners were selected in the examination, actually even thereafter, the result of Godda district has not been published. Now,
I just want to know from you, examination was held in 2011.
yes,
What have you done from 2011 till 2023? This is 23 times. What have you done?
my lord, in my humble submission, other person petitioners, home guard, had filed it petition before the honorable court. That order we have annexed,
Yes.
and the honorable court had directed the respondents to publish the results, second list of the results for appointment of home guard. That order of the honorable court was challenged in
Second list.
Madam?
So first list must have been published.
Published thereafter for the second list.
Your
of-
name was there in the first list.
First list was published of the other district, not of
Other
the Godda.
district. We are not concerned with other district. You
Because
just tell
of
us
the-
about this
because
district.
of provisions in my humble submission that Godda district is in the state of Jharkhand. And on the basis of the same advertisement number 1 of 2009, appointment was made.
Whether these posts have been advertised subsequently.
This advertisement,
This particular post, in connection with which you are seeking the declaration of result, has it been subsequently advertised?
no, once prior to 1 2009. Perhaps I'm not clear to you, Lordship, in my humble submission. Lordship may kindly take into consideration
You just give me the list of dates.
Madam?
I just want to know 4-5 dates.
Yes.
Examination held in 2011.
11. Yes.
Result declared, not declared.
Not declared.
Not declared. So after 2011
Yes.
till 2023, what were you doing? I just want to know the answer to this question.
We are repeatedly making requests to the respondents to publish the result. Now, when the petitioner came to learn that this honorable court, in my humble submission, had directed the respondents to publish second list for appointment of home guards for
Where
the
is your representation?
Madam?
Where is your representation?
Representation. बताइए. Annexer, page number 92-95. Page number 92-95, Lordship पे जाएंगे पेरोज. Page number, annexer 13, page 93. 93.
Page number 93.
Right. 40% said sign in this representation.
Kindly read it.
May I read it, madam? Kindly see, madam, जिला संबंधिष्टा कार्यालय गृह रक्षा वाहिनी गोड्डा विज्ञापन 1/2009 के तहत गोड्डा जिला के 9 चयनित गृह रक्षकों का मेगा सूची प्रकाशन के संबंध वहां से निवेदन पूर्वक कहना है कि हम लोग उक्त विज्ञापन के आलोक में गृह रक्षकों के लिए आवेदन दिया. आवेदन के आलोक में दौड़ आदि जांच हुआ, इसमें हम लोग सफल हुए. सिर्फ मेगा सूची प्रकाशित करना रह गया था, परंतु लंबे समय बीत जाने के बाद प्रकाशित नहीं हुआ. श्रीमान से निवेदन पूर्वक कहना है कि अब हम लोगों का ऊँट भी नहीं बचा है और न ही किसी दूसरे बहाली में हम लोग कार्य फॉर्म अप्लाई भी नहीं कर सकते हैं. अतः श्रीमान से आग्रह है कि उक्त मेगा सूची को यथाशीघ्र प्रकाशित किया जाए. हम लोगों का एज भी खत्म हो गया है. वी कैन नॉट मेक एप्लीकेशन फॉर अपॉइंटमेंट.
पेज नंबर 95 में आए.
95. काइंडली सी बोले. झारखंड विज्ञापन संख्या 1/2009 गोड्डा जिला के 9 चयनित गृह रक्षकों को मेगा सूची प्रकाशन करने के संबंध में तथा नया विज्ञापन संख्या 1/18 की चयन प्रक्रिया को रोकने के संबंध में सवनीय नम्र निवेदन यह है कि विज्ञापन संख्या 1/2009 में झारखंड के सभी 22 जिला में गृह रक्षकों का बहाली निकाला गया था. इसमें शारीरिक जांच परीक्षा भी लिया गया था तथा सभी जिले के अभ्यर्थियों की बहाली की गई तथा वे लोग सभी अभी कार्यरत हैं. परंतु हम लोग गोड्डा जिला के अभ्यर्थियों का चयन के बावजूद मेगा सूची प्रकाशित नहीं किया गया. कार्य जिले के तत्कालीन समादेष्टा उपायुक्त एवं पुलिस अधीक्षक को अमानवीय स्वच्छाचारिता तथा अपने अधिकारों का दुरुपयोग करते हुए किया गया. अभी वर्तमान में उस मेगा सूची को प्रकाशित न करके वर्ष 2018 में निकाले गए विज्ञापन की चयन प्रक्रिया शुरू की जा रही है, जो दिनांक 16/1/23 से प्रारंभ है. अतः पुनः मनमानी पूर्वक यह कार्य किया जा रहा है. अतः श्रीमान से निवेदन है कि वर्ष 2009 के चयनित अभ्यर्थियों को मेगा सूची प्रकाशित कर उसे प्रशिक्षण कराया जाए तथा उक्त नए चयन प्रक्रिया पर अविलंब रोक लगाने की कृपा की जाए. उसके बाद एनेक्सर 4 देखा जाएगा.
उसके बाद एक सेकंड राउंड भी हो गया और उसके बाद सिलेक्शन भी हो गया.
सिलेक्शन जो है
सिलेक्शन
एनेक्सर 4 में काइंडली भी पेरोज. एनेक्सर 4 हम पढ़ देते हैं. कमिटी ने क्या डिसीजन लिया, पेज 58-59 में देख लिया. नहीं है. पेज नंबर 58 लॉर्डशिप में काइंडली पेरोज मैडम. The decision of the committee madam signed this.
इसी के साथ चला जाओ.
Lordship got it. page number
Okay,
15.
they took some decision that it should be published.
Madam?
This is 2011 decision.
Yes, yes. Now what they have taken decision, madam, kindly peruse, madam. I am placing for of the kind consideration. Kindly peruse it, madam. पंजी के अनुसार the 5-member committee had taken this decision. गृह रक्षक नामांकन हेतु विज्ञापन संख्या 1/2009 दिनांक 11/7/2009 द्वारा समाचार पत्र के माध्यम से विज्ञापन निकालकर इच्छुक उम्मीदवारों से आवेदन आमंत्रित किया गया। विज्ञापन में यह दर्शाया गया कि उम्मीदवारों को शारीरिक रूप से स्वस्थ एवं सभी प्रकार के कर्तव्य निर्वहन में सक्षम होना चाहिए, जिसकी जांच जिला जेल समिति द्वारा निर्धारित प्रक्रिया के द्वारा की जाएगी। तदनुसार 23/8/2009 को विज्ञापित स्थानीय समाचार पत्र के माध्यम से दिनांक 27/8/2009 से 29/8/2009 तक शारीरिक जांच कार्यक्रम निर्धारित किया
Just a
गया।
moment, just a moment. Let me just figure out what is the stand of the respondent. They are seeking time. I'll post it tomorrow. But let me just figure it out. What is your stand in the counter affidavit? Why didn't you publish the result?
Lordship, firstly, Lordship, the advertisement number 1 of 2009 was struck down, Your Lordship. Thereafter,
Struck down by this court?
Struck down that what we have stated in the counter affidavit.
Where is it? Where have you stated?
Even not, Lordship, at annexure 11 of the writ petition, Your Lordship, they have filed one RTI, Lordship, and that we have replied that the same was struck down by the order of the Honorable High Court.
What is the case number, please? What is the case number?
Was not in the reply of the RTI application.
You are not aware. In the RTI, it is not there. Is it there in your counter affidavit?
05 of 2012.
Sorry?
5605 of 2012.
5605 of 2012. Ordinary
The matter
case.
was taken up in that credit application.
Okay.
And it has not been, after that, for the result of the selection process, the matter was taken up. And firstly, it was disposed of. Then the state has preferred civil review for after the disposal of the 5605, and the Honorable Court, and then they went for the contempt case of 27 of 2013, Your Ladyship. And in that, the direction was given, whenever there is power vested in the government, there is no corresponding right vested in the public at large, and there is no public duty vested in the government, and hence no writ of mandamus can be issued for the alleged breach.
Where is that order? You have annexed along with the counter affidavit.
Your Ladyship, we have annexed. I am appearing in serial number 30.
In another case, you have annexed it.
Same was at annexure D6.
Annexure D, page 40. We have annexed the copy of the Civil Review 1 of 2013 and Contempt Case 27 of 2013. And the Advertisement 1 of 2009, dated 11 July 2009.
I want to see all these orders.
Your Ladyship,
One is Civil Review number 11 of 2013, other is WPS number 5605 of 2012, and third contempt also. Contempt case number?
Contempt case, Your Ladyship, 27 of 2013.
27 of 2013.
And the government has dropped the public advertisement 1 of 2009, Your Ladyship, in that.
By which order? Where is that order by which this particular advertisement and the recruitment pursuant to this?
In Civil Review 11 of 13, Your Ladyship. And that is annexed in page 40, that is annexure D. Page 41 is contempt, 27 of 2013, page 41, and 40 is Civil Review.
Civil review was allowed and the order was recalled,
Yes, Your Ladyship.
isn't it?
Yes, Your Ladyship.
The state government has dropped the publication of this advertisement number 1 of 2009.
2009, yes, Your Ladyship.
Then content was also dropped because the civil review was allowed,
Yes, Your Ladyship.
right? चलिए, अब आपको कल चाहिए?
As you read.
You are praying for time. I do not know. Okay.
Has
अब सुन लिए? Your advertisement 1 of 2009 was dropped, and ultimately the initial writ petition which was disposed of on WPS number 5605 of 2012, directing them to publish the result, was reviewed in civil review, and that order was recalled and the contempt was also dropped. So you want the same order which was passed in 5605 of 2012.
Perhaps if I humble.
This is short and small of your case.
What I'm
You may
submitting-
respond to it tomorrow because they are seeking.
I will respond. But
Not now.
before
I just wanted to have a broad idea of the case such that I will go through the records accordingly.
Definitely my notes will go through that, but one thing I want to point out for of the time consideration. Paragraph 12 of the writ petition, we have categorically stated that on the basis of the advertisement made on 1/2009, the respondent has given appointment to Home Guard in 2015. We have given the
You
list.
challenge their appointment.
Madam?
You challenge their appointment.
I am saying, what I am saying, at one place they are saying that the advertisement was dropped, the state. One place they are saying that has been set aside by the honorable court. Which statement is correct? Whether it has been set aside
We
or
shall
whether it
examine
has been
it.
dropped.
We shall examine it.
It will be according to Home Guard rules. Earlier, police manual was taken up. Then after the civil review, after the judgment, then in page 20, we have the Honorable Court has directed the new selection process will be initiated by Home Guard Rule 2014 regulation.
And thereafter, 2015, you have done the needful.
In 2018, again new fresh advertisement.
He says that in 2015, certain appointments were made. Which paragraph? Which paragraph of your writ
12
petition?
पे लिखे हैं लोग, हम लोग document में
नाम भी
लिखे हैं।
लिखे होंगे ना किनका
जी,
अपॉइंटमेंट?
सबका लिखे हैं, सबका लिखे हैं नाम। Annexure 7 है।
But the same is for
And they have,
Dumka
my
district.
lord, one thing I want to point out, that they have not denied by this statement made in the writ petition.
We'll see that.
Now, in my humble submission, if lordship may favor the counter affidavit, no denial. Now, in my humble
No,
submission.
we'll see that. We'll see.
My lord,
We will see that.
yes, then it is a settled principle of law that the environment made in the writ petition is not denied in the counter affidavit, that will amount to acceptance of the statement made in the writ petition. That was Article 14 and 16(1) of the Constitution of India, equality before law. Person in like situation and like circumstances are entitled to be treated as others.
Lordship, but the same is for the Dumka district, Lordship, the para number 12 that they are mentioning. Lordship.
The advertisement number, this 1 of 2009 was only for Dumka district. It was not for
Entire
Dumka
state.
district. It was for the entire state. How do you respond to para number 12 of the writ petition? It's a matter of record. Is it a matter of record that out of the same advertisement you are giving this? Boy, you just see what is your reply to para number 12 of the.
No reply.
Where is your counter
Not
affidavit?
denied. Because
Where is your reply to para number 12 of the
At
writ
para
petition?
number 26, Lordship, we have replied. that
Of the
same
counter
was-
affidavit?
Yes, Lordship.
Para 26 lordship may kindly
That we
period
have
the counter affidavit.
Just a moment, sir. Please hold on. Where is your counter affidavit in this case? I have this
I am appearing in Ravi Shankar Singh.
in Ravi Shankar Singh. It is there. Where is your counter affidavit in this case?
19/23/5.
This is rejoinder. This is rejoinder. इसी को counter का intent का भी.
Para 26 lordship.
Current one we have only stated and submitted. The same is not, so we have not lied in detail your petition.
You don't need to. If it is not true. इसमें है काउंटर।
इसी के साथ इसमें काउंटर
इसके साथ ही है ये।
3 केस है।
अच्छा,
थर्ड केस
which paragraph? Para number 12.
26, para 26 of the contract.
I do not know. In this particular case, there is no counter affidavit. WPS 152 of 2023. नहीं है।
152 of 23, your ladyship, we have filed 13.
WPS number 2656 of 2023. In this
That it is not there on the record.
152.
copy come
152 counter
they have
affidavit.
sent me copy.
ये क्या है? अच्छा ये।
But it has been filed.
No 152. Sorry, there is one more. एक और है ना record?
ये में फाइल
इसमें है
2656
2656.
Yes, Lordship. I have
2656.
You have filed your counter?
Yes, Lordship. We have filed.
देखिए चेक करिए तो फाइल किए हैं। Same pleading here also, identical, same paragraph.
इसमें एफिडेविट किया हुआ है 19/12/23 का।
26.
No, it is
Your
not the
ladyship, in 152, I have replied in para 24, that is page 30.
काउंटर फाइल नहीं किए आप।
2656
Counter file कर दिए।
नहीं 2653 में नहीं हुआ।
2656
This para number please.
In case number 152 of 23, we have replied para 12 in para 24 in page 30.
It is not the same paragraph.
In para 24, that is with regard to statement made in para 12 of the writ application.
No, it is not the same paragraph. Show me your reply. What is your reply to? You have not filed it, mister.
Lordship, we have filed. Lordship, I will check in the office.
You don't take out the print of the filings from the portal.
Lordship,
When did you file it?
on 8/2/2024, Lordship. That the same was written.
काउंटर फाइलिंग
The counter has not been filed. Rejoinder has been. It has not been filed.
152.
Para 12 of all the petitions are different.
Paragraphs are different.
So,
ये भी है ये 2606
कहीं डिनाइल नहीं है उसमें।
declaration of result does not mean that they have been appointed, because there is a fatal that particular advertisement by itself was recalled. Where they issued appointment letters, are they working?
Yes.
हाँ वो काम कर रहे हैं।
सब कर रहे हैं।
आपका यही स्टेटमेंट लिखा के इनसे मांगते हैं हम जवाब।
हाँ
ठीक है।
गलत नहीं होना चाहिए। आप
गलत
क्लाइंट
नहीं
लोग
होना
पीछे बैठे हैं, पूछ के बताइए।
कर रहे हैं ना।
पीछे बैठे हैं, पूछ के बताइए, और जो आदमी बताएगा उसका नाम भी बताइए हमको।
पूछ लीजिए।
You respond to this. You can't get away with this. This record para number this one. आपने तो काउंटर ही नहीं फाइल किया.
Lordship, I will verify the same.
WPS number 2656 of 2023.
There are three cases. There are three cases.
29, 30 and 31 serial.
Same कहानी है ना, same story.
Same story for the same district.
This is district of Godda.
Godda.
The Learned Counsel for the and analogous cases, the Learned Counsel for the parties have submitted that the petitioners had participated in the selection process pursuant to advertisement number 1 of 2009. But and as per them, they were successful, but the result has not been declared. The Learned Counsel have also submitted that the Learned Counsel for the state has referred to the counter affidavit filed in WPS number 152 of 2023 and has referred to order passed in WPS number 5605 of 2012, wherein a direction was issued wherein the Council for the State had submitted that the result would be declared within 60 days from 8/10/2012, and accordingly the writ petition was disposed of. However, the order passed in the said case was subject matter of civil review number 11 of 2013, and the order passed in WPS number 5605 of 2012 was recalled and a civil review was allowed by observing that, and ultimately the writ petition was dismissed inter alia on the ground on the following grounds: A, the state government has dropped public advertisement number 1 of 2009. B, the result of not a single candidate has been declared of the examination taken in pursuance of public advertisement number 1 of 2009. C, there is no violation of right vested in the petitioner, nor there is any violation of public duty. D, there is no prejudice caused to the respondent, the original writ petitioner. The Learned Counsel for the petitioner has referred to paragraph number 12 of the writ petition, and on instructions from one of his clients has submitted that everywhere candidates have been selected pursuant to advertisement number 1 of 2009, excluding the Godda district, and 244 candidates of Dumka district were selected under the same advertisement, and their result was published on 14/12/2015. The Learned Counsel submits that the candidates whose results were published on 14/12/2015 in the district of Dumka have been selected pursuant to advertisement number 1 of 2009 and are performing their duties. They have also submitted that the list of such candidates has been mentioned in page number
Page number, Annexure 7, page 63.
Annexure 7, page
63. That total number
73 list of from 60 to 63 to 73.
Annexure 7. It starts from page number 63.
Edition 152, page 41 is annexure 7.
Repetition. 2656 वाला 2656 वाला repetition में from 62
Page number?
from 62 to 72
73.
Where does it say? Where does it say that it is being published pursuant to the advertisement of 20?
Out of 12 we have given.
No, you have given, but where does this document say that it is a publication of result?
Out of 12 में हम लोगों ने जो लिखा है मैडम, I'm reading from my kind contribution.
I have seen it. I have recorded it also.
Yes.
But on the face of annexure 7, does it indicate? And they are still working. The learned counsel for the respondents is directed to seek instructions from the respondent number. Who will file this affidavit? बताइए, who will file this affidavit? Yes. Respond number 1. He should file the affidavit. Respond number 1. And file an affidavit with specific response to para number 12 of the writ petition. At this, the counsel for the petition respondents has submitted that, as per his records, a counter affidavit has been filed, though the same is not reflecting in the क्या बोलते हैं इसको? In the computer entry of this court. He submits that he shall file the counter affidavit, as a rejoinder to the counter affidavit has also been filed. There is specific response to para 12.
Yes, Your Lordship, we will file the same.
The learned counsel submits that there is no specific reply to paragraph 12 of the writ petition, and the affidavit will be filed within a period of 2 weeks from today.
And reply.
Let the counter affidavit, whose copy has been served upon the petitioner, though not filed in this court, be filed within a period of 1 week from today. आप खोजिए, आपके पास होगा कहीं, right? And the supplementary counter affidavit be filed within a period of 2 weeks from today, in light of the aforesaid observations made by this court.
Glossy may kindly fix one date, madam. Any date subject to minus time can be moved.
Pose this case on ninth April. Let this matter be treated as part of
9th April or
Earlier.
IA for early hearing is closed. You complete your pleading. See, आप लोग कुछ check नहीं करते हैं. ये computer system आपको गलत access देती है, because you don't do anything.
Lordship, actually the same was even showing in the record of the Advocate General Office.
आपके record से court का record match नहीं करेगा तो हम कौन सा record मानेंगे?
Lordship, I will check the same, Lordship, and I will file the same with the Advocate.
This computer system is there, you have the access.
Yes, Lordship.
Then why don't you take out a print?
Within a week.
You have to clarify this position. You can't have it both ways. application की दिलाई को लिखा है इसमें। You have come up with your
Yes, soft copy also I have forwarded to the.
दिखाई जरा
To the board. I'll place only minutes 10 minutes of
No,
argument.
not 10 minutes. There is already a matter fixed for judgment. Just I've heard you. I've heard you fully. You have got
Yes.
a copy of this, whatever he has said?
Yes, sir. This is just 100 minutes. And soft copy also I have forwarded to the board.
That's
Only two judgment, not two, first two judgment.
You are not supposed to forward the soft copy to the court master. You are just supposed to always
Yes,
provide a soft copy in pen drive to our stenographer for their convenience. Once you have filed it, it is there with us. There is no problem. Likhit WPS number 4886 of 2023. The learned counsel for the petitioner has filed short notes during the court proceedings, which is taken on record. That's it.
My lord.
We'll post it for judgment.
Yes,
Arguments concluded.
yes. But I would like to place a few things with your lordship. So, motion I have not
You
yet.
want to place something?
With your lordship. Otherwise, I can get.
We have heard you fully. You have added anything new?
No, no, I have not been heard, your lordship. I have not heard.
You have not argued this
Not
case?
at all.
At all?
At all.
You argued this.
My lord. If your lordship, the petitioner has bought a number of circulars of the personal department, your lordship, which are annexure, which we placed 3 of them, your lordship, annexure 2 to the rules, your lordship, the rules framed by the personal department, annexure 4, the 2019 rules, the earlier rules, your lordship. Your lordship has all that. But there is a further background to this. I invite your lordship's attention to the counter affidavit filed by the Department of Personnel, this particular case, which is the respondent number 2.
Respondent number 3 has a separate counter.
Yes, yes. They have made, in this case, they have made personnel, urban development and energy.
5 and 6 is a separate counter.
Yes, yes. 5 and 6.
All department have filed a separate
Respondent
counter.
number 4 has a separate counter.
Yes, your lordship. I was inviting your lordship to respond number 2's counter, personnel department.
Respondent number 2. Okay.
My lord,
Yes.
in this case, your lordship, I have annexed there have been subsequent amendments also, 23 rules, that is annexure A, that is not very relevant, by the Department of Personnel. We have got that on record also. But annexure B is very relevant, your lordship, which starts from page 45 of the counter affidavit.
Annexure B.
My lord.
Page 45.
Lordship.
Okay.
This is issued by the Path Nirman Vibhag, your lordship.
Annexure B is Path Nirman Vibhag. Yes.
झारखंड अवर अभियंत्रण सवर्ण कन्या अभियंता सिविल विद्युत यांत्रिक सेवा नियमावली 2013. These are the service rules, your lordship. Now, so your lordship, the next page, the relevant portion is at page 47. Page 47.
Yes.
Top of the page. न्यूनतम तकनीकी योग्यता. झारखंड कर्मचारी चयन आयोग द्वारा विज्ञापित आवेदन जमा करने की अंतिम तिथि को विधि द्वारा स्थापित एवं केंद्र सरकार / राज्य सरकार द्वारा मान्यता प्राप्त संस्थान अथवा अखिल भारतीय तकनीकी शिक्षा परिषद द्वारा मान्यता प्राप्त संस्थान से सिविल विद्युत यांत्रिक अभियांत्रिकी में डिप्लोमा अथवा समकक्ष योग्यता उच्च तकनीकी योग्यताधारी भी आवेदन के पात्र होंगे. My lord, these are the service rules which have been framed by the road construction department.
That's right.
The subsequent circulars of the personnel department flow from here, your lords. But these circulars are not under challenge, nor is the road construction department pleaded as a party, your lord. They are a necessary party. because their challenge is just to the circulars by which these for the vacancies, Your Lordship, and for the conduct of examination circulars.
They want interpretation of this
Yes.
clause
My lord, this
by
clause
saying that this particular clause would essentially mean that the additional qualification of Uch Takniki Yogyata Dhari would be in addition to diploma.
I appreciate that, Your Lordship, but my submission was that the road construction department is a necessary party, because if Your Lordship,
This advertisement is for which department?
it includes road construction also amongst other. That is another interesting thing.
But I have not applied for that. I have applied only for route department
Let
because
me-
I am an
then if you-
electrical engineer. An electrical
If you-
engineer, the only two posts were
Just hold on.
floated.
Yes.
My lord,
Only to clarify, my lord. Only two
Please
posts.
hold on. Don't be simultaneous. Yes.
my lord, here the advertisements were for drinking water department and sanitation department. They are not a party. They were for water resources department. They are not a party. Road construction department. They are not a party. They will be affected if Your Lordship holds that these departments will be affected. He may not be a candidate for those departments. Plus, but those departments, they are also covered by the advertisement. And second, we will be faced with a situation where the examination conduct rules are interpreted in a certain manner by this honorable court, without the original rules, which have been framed by the road construction department. They have not been heard, Your Lordship. They necessarily have to be heard. Not in this case, the other case which is there. 5 months ago, we filed counter affidavit with saying that this was filed on 6/10/2023, saying that road construction department is a necessary party.
There are two cases.
The two cases, Your Lordship, two cases. The second case, this case, the counter affidavit is more recent, but in the other case, on 6/10/2023, my counter affidavit is filed by personnel saying these rules have been framed by the road construction department and under Article 309 of the Constitution. They are a necessary party.
Road construction department has framed the rules,
My lord,
but these rules are applicable to other departments also.
Yes, for these are service rules, Your Lordship. These are service rules.
No. You see, when you say that these particular rules have been framed only by the road construction department,
My lord.
ipso facto it will apply to other departments also.
It has been framed. It is for the other area also, because this
No,
is Jharkhand.
when you see, when a department is framing the rules, it is only for the department.
My lord, this is Jharkhand Avar Abhyantran Sang Niyamwali 2013. I also try to understand how this department did it under what pass. The
Yes.
road construction has to come and explain that. But this is for all of Jharkhand. That is what the stand has been taken by the personnel department.
As per the advertisement, they are governed by this rule.
My lord, these are the service rules. And
Is
the
it mentioned in the advertisement that they are governed
No,
by
there is
these
no
rules?
mention. There is no
There is
mention.
no mention.
But Your Lordship, these are the original service rules with the same.
When you talk about service rules framed by a particular department,
For all of Jharkhand.
how does road construction department frame rules for all over
Let them
Jharkhand?
come and explain under the
We
rules
do
of
not know.
My
On
lord.
the face of it, it does not reflect that it is for whole of Jharkhand.
It is, Your Lordship. It is because it says Jharkhand Avar Abhyantran Swarg Niyamwali.
Framed by road construction
Yes, Your
department.
Lordship.
In the year 2015,
My lord, paragraph 13 of my pleadings, personal department, that is further stated and humbly submitted that the minimum education qualification for posts, my lord, page 25 of the personal department's counter affidavit. That it is further stated and humbly submitted that the minimum education qualification for posts in the said examination rules and also in the advertisement have been fixed in accordance with the provisions laid down by the Jharkhand Junior Engineering Cadre, Junior Engineer Civil Mechanical Electrical Service Rules 2013 as framed by the Road Construction Department, Government of Jharkhand by its notification under this matter. So this is for all of Jharkhand. Then after that I have quoted this here, then there is a specific stand in this counter affidavit that RCD should, we have also written to the RCD, the personal department also wrote to the RCD. And there is a specific stand taken, this is applicable. So the service rules, but these rules are not, these have not been challenged or clarified.
2015, the personal department framed a new rule saying that Jharkhand Chayan Ayog Pariksha Diploma Star Sanchalit Niyam Wali. And that particular rule later on amended by the personal department, which I have showed to your ladyship twice, by adding the Uch Takniki Yogyata. So how 2013 rule for the road construction department will be applicable for 7 to 8 other departments, where I am nowhere concerned with. My appointment will be purely with the urban department or Milord's energy department, because I am an electrical engineer, not a civil engineer. So my service will not be required for the road construction department anyway. And no, Department of Personnel is the parent department who always frame the rule for any appointment across Jharkhand, Milords.
There is 2015 rules. You
Yes,
have
Lord.
annexed.
Annexure 4, page 85 of the writ.
Do you want to say that the rules of 2015 as annexed in the writ petition is not applicable for the road construction department and they are governed by 2013?
Those are examination rules. These are service rules. Examination rules. 2015 are examination rules. यह नियमावली झारखंड कर्मचारी चयन आयोग परीक्षा डिप्लोमा स्तर संचालन नियमावली 2015 conduct of examination rules, your lordship. Those are service rules. There cannot be a dichotomy between the two rules. And those are junior engineer service rules. Perhaps the power was rightly or wrongly, I am not going into that, was perhaps delegated to the road construction because it is specifically under Article 309 of the Constitution. And it should be to my counter affidavit.
This is also 309. And this rule was
My
amended.
lordship.
There is no prayer to. There is no prayer seeking challenge to that particular provision.
There isn't, your lordship.
There is no. They are basically seeking interpretation of the rules.
My lord, and for that I will just be placing one citation with your lordship. Old judgment, it is for a writ of certiorari. We are not in a situation of certiorari, but the broad principle.
They are not seeking any certiorari.
I am not saying that, your lordship, but the broad principle, your lordship, the broad principle. This is a 63 Supreme Court
You
judgment.
see, the person who has passed an order, he is a necessary party for in all cases of certiorari.
My lord, here this, that is definitely there, your lordship. Apart from that, this at, my lord, the last page. Those parties whose action, my lord, the third paragraph from the top, those parties whose action is to be reviewed and who are interested therein and affected thereby. My lord, here I would submit that even if we limit ourselves to the advertisement, the departments which have not been implemented as parties, they are also interested. And in whose possession the record of such action remains. My lord, I would submit that the road construction department is a necessary party. They have the record of action on the basis of which the service rules were framed. In consonance with the service rules, the examination rules were framed.
You are concerned with which department?
Urban Development and Energy Department.
The advertisement includes drinking water, water resources, and road construction department. Of course, not in his field, but
Drinking water?
water resources and road construction. The advertisement has all of them.
They can apply for different departments. Is there any option that you can apply for different departments? It's en bloc. No, when you make an application,
Yes, Lord.
you apply department wise.
Yes, Lords, because two department has floated the post for electrical engineer, that is Urban Development Department and Energy Department. And other department has floated for different engineering stream, like mechanical, civil, agriculture, etc. So I am not eligible. So I am eligible only for two department who has floated for electrical engineer, junior engineer post. They are urban and energy.
Apart from this plea, do you have anything
No,
else to
nothing else,
say
Your
on the
Lordship.
interpretation?
My lord, nothing else apart from these departments will also be affected by the interpretation of this honorable court. So they have a right to be heard.
Otherwise, your contention is, what is your contention? You forget about this particular, because you are representing the entire state now.
My lord.
So what is your contention so far as the interpretation which has been proposed by the petitioner is concerned?
My lord, I That particular, there is no specific. The only stand is that the road construction is the proper authority to answer this question, Your Lordship, and they are not the party.
Even on the point of interpretation.
My Lord, in the entire thing, how this rule was framed, what they meant, they will have minutes, they will have expert committee meetings, perhaps, I don't know. They will.
And what about the other respondents who have filed the counter?
They have said the same things. They have said the same thing. The other respondent, even if personal is saying this, Your Lordship, what can energy say and what can urban development say? They have said more or less the same things.
The question of referring to the other records comes only when there is an ambiguity in the route, isn't it? If the rule is clear,
then
there is no
requirement for
there is no
interpretation.
requirement.
There is no requirement for
No,
interpretation.
they are seeking an interpretation. But if the rule is clear, then there is no requirement to see the backup files. Is there any requirement?
My Lord,
it has a statutory force under
My
Article.
Lord, perhaps not the backup file, but the department which framed the original service rules, they should be heard for a proper interpretation. They have to give their logic for what they meant. Perhaps their interpretation may be in favor of the petitioner. I do not know.
We do not know.
But road construction will not, without being a party, they will not brief me, Your Lordship. So, the original service rules until they are interpreted, Your Lordship, because the examination rules cannot have different service conditions as to the original service rules. It flows from there.
This is very peculiar. The original service rules has been framed only by road construction department.
Well, one particular department has to frame. Usually it would be the personal department. But I have found in other cases also there have been overlapping jurisdictions, Your Lordship. For women's welfare, I always thought it would be child and women's welfare. But somewhere labor department is getting involved. Those opinion files also come to us. So, Your Lordship, we face those situations.
Rules framed by the road construction department, it itself is indicating that it is for the road construction
Why not for
department.
Jharkhand? Because that is what
No. You just have a look at your rules.
Yes, Your Lordship.
It says only for the road construction department. You
Your
just see
Lordship,
Bharat
Jharkhand-
के संविधान. You see करते हुए विद्यमान प्रावधानों को अवक्रमित करते हुए झारखंड राज्यपाल लोक निर्माण विभाग के अंतर्गत कनीय अभियंता. So
My Lord, this
लोक निर्माण विभाग के अंतर्गत कनीय अभियंता के पद पर नियुक्ति हेतु भर्ती सेवा शर्त तथा वेतन आदि का.
After that it says here Jharkhand.
No, how does it? On the very face of it, on the very face, the background, it is mentioned.
My Lord.
You ignore that.
My Lord, but they have stated this year. But after that it's here नियम वाली झारखंड अवर अभियंत्रण स्वर्ग नियम वाली 2013 कहलाएगी. It doesn't say road construction department का कहलाएगा. And after that, even the specific stand of the personal department is that this is for the state of Jharkhand. And then at page 61, Your Lordship, of this particular year.
And it has been communicated to
Then after that, page
That's all you want to say.
My Lord, the last page of this, page 57, Your Lordship. Page 57, point 31. This is the repeal and savings clause, Your Lordship, of this. यह नियमावली को प्रयुक्त होने की तिथि से पूर्व झारखंड में लागू संबंधित नियमावली निरस्त हो जाएंगे या एवं कोई कार्य या कार्रवाई जो पूर्व में लागू नियमावली के अंतर्गत की गई हो के संबंध में यह माना जाएगा कि इस नियमावली के अधीन की गई है. And next page it is marked to everybody, Your Lordship, to numerous departments at page 58.
The vacancy position is also qua the road construction department only.
No vacancy position.
Page number 48. 14 ka. Isn't it?
Why not I just place this? My lord, page 60. This is for the amendments to the 2013, page 60 of the counter. यह नियमावली झारखंड यह इसका विस्तार संपूर्ण झारखंड राज्य में होगा.
Now this is extended by this particular order to entire state of Jharkhand.
There have been, just like the earlier the examination rules, there were three amendments. There have been two in this, and there is a clear stand of the personnel department that this has been framed for all of Jharkhand. They say so in their affidavit.
So the personal department is there before us.
Yes,
to
they have.
represent the entire state of Jharkhand.
I was placing their counter affidavit only, Your Lordship, that these rules, the 2013 rules, need to be looked into. That this
We will look into that.
and that everything flows from there, Your Lordship. Our examination rules have been framed based on that, and so until that department is heard and they perhaps they may even. Their interpretation may be exactly what the petitioner wants. It may not be what the petitioner wants, but they need to be heard. My judgment is only on that point, that they are in possession of the record, and of course this is for certiorari, this is for declaration.
They are just seeking a declaration.
They are seeking.
We are just seeking to interpret the rules.
Which will have wide ramifications, Your Lordship. A lot of people will be.
But you have nothing to say on interpretation. You are silent on interpretation.
The road construction can say, we cannot say.
None of the respondents can say.
My lord.
The state of Jharkhand is being represented by.
My lord.
So you will have your the chief secretary is also there, a party representing all the departments.
My lord.
Right.
My lord.
So he will not say anything. Different departments will have their independent interpretation on the service rules governing the parties.
Not different.
Then.
Not different interpretations, Your Lordship.
When the chief secretary is there before the court, why should we call upon different departments to file their different affidavits?
My lord, the department which has framed necessarily should file one. That is my limited submission.
That's all?
That is my limited submission. They should be made a party and they should be made to file an affidavit.
Very short reply to this was the advertisement, the initial para first of the advertisement, all the notifications have been mentioned that from where this advertisement is floated, and all the departments have sent their different requisition through different letter to the JSSC for this appointment process, and in a consolidated manner the JSSC has published the advertisement for junior engineer in different stream for different departments. So the very first paragraph clarifies that it is not only for the road, and since I am not from the road construction, I have no concern, so I have not met the party. And there is a parallel rule, if I take the submission of my learned senior counsel, 2015 rule, which is specifically for this examination process, which were later on amended by the personnel department 2019 and 21. These rules are floated by the personnel department. In any examination process in the entire state of Jharkhand, the rule is always framed by the personnel department, which is a parent department made in the state of Jharkhand for seeing all these things, service rule, appointment rule, etc. This is all this.
This particular eligibility criteria has been specifically mentioned in the advertisement.
Yes, also.
Without referring to any particular backup.
Any backup.
It is as it is.
As it is. Is it as?
Even if there is some variation.
Yes.
Qua the rules.
Yes.
Then also such kind of conditions can be put during advertisement. If the government feels that maybe that the qualification is required to be enhanced,
yes,
Suppose the government feels that no, only BTech or MTech would be eligible for a particular examination, they can take a call to that effect.
Yes, ma'am. But pursuant to publication of notification of rule and then the advertisement, because rule is always guided by a advertisement law. Advertisement is a kind of a contract notes which the candidate enter once he's fill up the examination form. Advertisement is being prepared by the JSSC as in completely in consonance with the rules, because notes the JSSC is only the examination conducting body. Their duty is to conduct examination and recommend. Later on, it is the duty of a state whether to accept it or not. In many of the examinations, they have rejected the recommendation of JSSC in town planner examination, and that is a judgment there to not upheld in Supreme Court. So their duty is to only to conduct the examination strictly in accordance with
And
rule
these terms and
regulation.
conditions of the advertisement is also being forwarded by the state only.
State only, because
It is the
repetition-
state government who is
It is
forwarding the
state
terms
government.
and conditions
Yes.
of advertisement?
Yes, sir. In this case, an exit 5, the rule 2021 in exit 6 on the basis of this, we have made the advertisement, and word by word it's same here also. We are just examination conducting authority. We can't add or subtract with regard to the qualification and age reduction and all that. That's on page 100 you lost it. After page 100 of the red petition, that कुछ तकनीकी योग्यताधारी भी आवेदन के पात्र होंगे as the 2021 rules, and in the advertisement also the same है that संबंधित शाखा में कुछ तकनीकी योग्यताधारित करने वाले व्यक्ति भी आवेदन देने के पात्र हैं.
Yes, even in the examination rules, the need was felt to amend the original 2015 examination rules.
And same thing has been happened.
What was there in the 2013 rules? The original 2015 rules, they had missed this, so they brought it in by amendment.
You also file your short synopsis. You have not done the needful. You file it by tomorrow. This little thing you can just put in.
Well, if I can have one more date, more around 40 odd cases.
Day after tomorrow. The learned counsel for the parties are present. Purana order हटा दीजिए. The learned counsel for the petitioner has filed a short notes of argument. The learned counsel for the respondents submit that the matter be posted day after tomorrow so that they may also do the needful post day after 2:15.
But
There was one judgment which I was about to dictate. Yes, I'm just pronouncing. I will dismiss that writ petition. I will go and give the dictation. I have dismissed your writ.
Yes, only for the clarification. Only 1 minute. Only 1 minute. Only for the clarification. I placed two judgments of the Honorable Justice of the single bench and subsequently the Supreme Court. Only for the clarification that 2015 judgment was not challenged before the Honorable Court. 2018 judgment which was passed, which was challenged before the Honorable Supreme Court. That is the judgment. 2015 वाला और जो 2021 में नहीं चैलेंज हुआ था. 2018 का जो जजमेंट था, जो LPA में 2020 में जजमेंट हुआ है, वो चैलेंज हुआ.
कहाँ है LPA ऑर्डर?
ये जजमेंट का बस ये क्लैरिफिकेशन. और वो जो जजमेंट का है 2018 का जो जजमेंट है वो केवल एक पॉइंट पे इन्होंने जो सोफार 2015 का जो हम रिलाई अपॉन किए हैं 2018 का जो जजमेंट है वो जजमेंट 2020 में LPA में उसको अपील कर.
कहाँ है LPA का ऑर्डर?
LPA ये 2000 दे रहे हैं उसको.
ये मतलब आफ्टर कंक्लूजन ऑफ आर्गुमेंट, आफ्टर
नहीं,
प्रोनाउंसमेंट
केवल
ऑफ
क्लैरिफिकेशन, ओनली फॉर द क्लैरिफिकेशन.
व्हाट क्लैरिफिकेशन?
एक और
1 घंटा आपको सुने हैं, अभी आपको क्लैरिफिकेशन चाहिए?
ये 2018 का है और जो 2021 का जो जजमेंट है वो
आपकी बात हमको ना बिना ऑर्डर देके समझ में नहीं आती.
तो इसको
नहीं हो गया, आई हैव ऑलरेडी डिस्कस्ड.
हाँ तो ठीक है, डिसमिस है, कोई दिक्कत नहीं है. केवल इट में भी टेकन ऑन रिकॉर्ड 2015 का जजमेंट.
वी डू नॉट नो, यू वांट थिंग्स टू बी टेकन ऑन रिकॉर्ड व्हिच यू आर नॉट प्रोड्यूसिंग बिफोर.
हाँ तो इसको एक ही है 2018 एक मैं